to a gag order to prevent attorneys from talking about the facts of the case or commenting about the credibility of witnesses, except in a courtroom, in a proceeding where both sides are present and the court is able to monitor and deal with it, and where the media can be present. So if they themselves say that, why are we not abiding by that? So again, and I'm finishing up with this part of my argument regarding the social media. I guess I'm referring to it as social media. I don't know if that's correct or not, but it's the legal website and Twitter, and I know they put Facebook to rest. But there is a concern in terms of the exposure of the public and in terms of commenting about the case. And I go again to Florida Bar Rule 4-3.6, which is what all the courts seem to relate in terms of what can a court legally do to prevent sides from talking about the case. Dissemination by means of public communication, if the lawyer knows or reasonably should know that it has a substantial likelihood of materially prejudicing an adjudicative proceeding due to its creation of an imminent and substantial detrimental effect on that proceeding. Are we not there yet? Aren't the commentaries that have already occurred doing that? Now let me highlight if I could, and I think, quite frankly, I had somebody try to Google Mr. O'Mara, and I don't mean to pick on him in terms of just defense counsel in this case, and you know, there was so much stuff. I'm just highlighting a few stuff. And now I am not implying in any way, nor am I stating that his comments, all of them, have been improper. I am not saying that at all. I believe, quite frankly, that Mr. O'Mara is an ethical lawyer and tries to do the best he can for his client and has done this in this case. And quite frankly, before doing the proceedings in this case, in fact, before I filed the first gag order, I said to him, and you know, he can state whether I said or not, because there'll be commentary about what was said. But the bottom line is, I said, I think you're crossing the line, but anyway, he has an obligation and he knows what he's supposed to do or not do. My concern is that I think we've overstepped that boundary. The defense counsel doesn't agree with that, based on their response. But I wanted to highlight certain things. Number one is the defense counsel then, with the defendant, went on national TV. And there the defendant, and on the Sean Hannity show, talked exclusively about the facts of the case. You know, quite frankly, that routinely would be improper. You might argue that's improper. That's talking about the facts of the case, and defense counsel's present. But I'm not objecting to that. I thought it was beneficial to the state, and I'm looking forward to using that and potential hearings for trial, if necessary. So I want to move on to then, I just highlighted a few instances as what I would submit are examples of where the line was crossed. And I'm on page 4 of my supplemental thing, memorandum. When defense counsel appeared on Piers Morgan on May the 17th of 2012, and he makes a comment about Mr. Morgan asks O'Mara if he agrees with the statement that if Zimmerman had stayed in his car, none of this would have happened. And Mr. O'Mara says yes. The same way as if Trayvon hadn't been in the complex, none of this would have happened. And then there's also talk later about the altercation and who started. But should that comment have been made? Is he responding to what Mr. Morgan said and that he has a right to, that is Mr. O'Mara? On June 21st, 2012, again with Piers Morgan, at approximately 1 minute in the interview, and let me preface this, Mr. Morgan asked O'Mara questions about the perjury claims against George and his wife. He labeled it as perjury claims. And O'Mara said that Zimmerman's credibility was affected, and he will have to deal with it, but his credibility isn't necessary for everything. And at approximately 1 minute into the interview, Mr. O'Mara said, as we discussed, his credibility was certainly affected. Now, he's talking about his client there, that his credibility was affected by the fact that he stand at mute when his wife said something that turned out to be misrepresentation to the court about the funds. And they're gonna have to deal with that. And he talks about the credibility. Should he be commenting about the credibility of his own client? On page 5 of my memorandum, Piers Morgan on July 17th. There's a quote from witness 9 regarding statements that she made, something happened to her when she was young, and it occurred by the actions of this defendant. Mr. O'Mara, in response to that, states something to the effect of, witness number 9 called police anonymously the day before and claimed the whole Zimmerman family was racist. And Mr. O'Mara referenced the FBI interviews of some people that said Zimmerman was not a racist. And he says because of this, her credibility is questioned. So you have potentially, the quote was, I would suggest that maybe her first statement suggested the racism questions her credibility. So the next day she makes up allegations about sexual abuse. So what we have now is a potential witness, may testify, may not, but a defense counsel commenting about the credibility of a witness. Is that not stepping over the line? I mean, are we going to have now every witness that is a potential witness in this case, defense counsel commenting about, oh, he's a credible witness, oh, she's not, he's credible, she's not. I mean, how far do we go? Okay, and if the court allows that, does then the state get to rebut and go, oh, he's credible, he's not? I mean, how far do we go? The next one I have is one that was done by a local TV station. I think it was WFTV. I think it's Orlando 9, August 13, 2012. Mr. O'Mara, in that interview, stated, I quote, I think, and I want to emphasize the word think, the facts suggest that in this case, that what probably, emphasize probably, happened was my client was reacting to having his nose broken, which I think, emphasize think, is probably undisputed that he had a broken nose now. Again, that's Mr. O'Mara commenting about what he thinks. So then, if it's fair, then the state the next day go, oh no, what it is his nose wasn't broken. I mean, are we going to have a back and forth every day? Competing news conferences as to what the state believes the evidence is, and then what, isn't that supposed to occur in a courtroom? Isn't that what we ask jurors to come and make a judgment on the credibility of witnesses and assess what was said or not said and get to the truth? But if we're going to partake in terms of both sides, because I would submit if the court's saying, okay, there's no necessary gag order, I think everything is said is proper, or I think something, anyway, whatever the court's ruling is, does that mean that the state gets to go up there and go, okay, this witness is credible, this witness is not? I don't believe this witness because of these. I ethically don't think I can do that. But if we're saying it's okay, I then want to move to now some newspaper articles, and there was a lot of them. Orlando Sentinel has covered this case exclusively, and so has the Miami Herald, and we pulled some of them. And I've listed the quotes, but I've got the actual articles here. So the court, thank you. If I may just put those into the record.
Any objections?
No, Your Honor, thank you.
And I've got actually extra copies if you want.
Exhibit 3.
And as I offer no objection, I'm sort of presuming for purposes of this hearing that we are completely waiving any suggestion of hearsay, because all of it is, but it sounds as though we're just sort of relaxing the rules of evidence for this purpose.
Well, I think for a gag order that the state is entitled to submit hearsay evidence.
And I agree, I just want to make sure it's clear.
The rules of evidence are not relaxed, it's just what is allowed in this type of a hearing.
For both the state and the defense.
Absolutely. Oh, it's 4, state's 4.
And what I've tendered to the court are evidence in terms of the Orlando Sentinel, September 29th, where Mr. O'Mara was interviewed. And he was asked questions. About the case. Now, on the page 7 of 9, at least from the top, in terms of the court hopefully being able to, I think it's page 7 of 9 of that, and the court obviously has the whole package there, but Mr. O'Mara makes comments about, I would submit that shouldn't have occurred. He states, he was asked about another attorney had a big mess to clean up when you joined the case. What do you say about that? That meaning Mr. O'Mara had a big thing to clean up from prior attorneys. And he says, obviously, I may not have allowed George to make all of the statements that he made to police. I'm not concerned that he made those statements now because I think they're all pretty consistent. Now, there he is commenting about facts of evidence. Quite frankly, there's other, I think in his legal website or in other places where he comments about they're inconsistent, but he can deal with them. And I think I've actually highlighted those for the court. But you have defense counsel now commenting about statements made by the defendant that they're consistent. And he talks about the one eyewitness who really seemed to see the events. He's commenting now about what a witness, well, there's a bunch of witnesses. Is now the state supposed to go, okay, hold on. How about the lady who was upstairs, who was looking down and saw something? How about the lady that was looking and saw people, one chasing another one? How about that? I mean, how far do we go in terms of trying to, this is what's occurring, we're trying to influence potential jurors. We want to get them on our side. That is, that's what the defense counsel is doing. Why else would you be commenting about facts of the case unless you're trying to convince people who are going to be the ultimate judges of this defendant's guilt or innocence to get on your side? Why else would you be making comments about this? Why is it necessary for defense counsel to speak about the facts of this case and to pass judgment or to talk about the credibility of witnesses, but for the fact that they want to influence not the public in general, well, obviously the public in general, but more particular, the potential jurors? Let me submit something to the court. Let's say we have a self-defense, stand your ground, whatever we call it. Let's say we have a hearing. Let's say that occurs in March. Are we then going to have commentary after that as to what exactly occurred or not if the court makes a proceeding that it should go to trial? Are we going to have then, well, when the defendant testified, what he really meant to say was this? I mean, is there going to be commentary about what occurred? I mean, how far do we go? On page 8 of that same interview of the defendant by the Orlando, I believe this is Orlando Sentinel, it's ironic that defense counsel is asked, is it getting harder for people to change their minds, isn't it? I'm sorry, it's getting harder for people to change their minds, isn't it? Answer, Mr. O'Mara, we're getting cemented in incomplete evidence. If I have a frustration about what I have to deal with in the courtroom, now we have to deal with those potential jurors who have incomplete information. So what is occurring now? He's going to fill in the blanks on favorable stuff so that they have a complete information of potential jurors. Your Honor, with all due respect, have we not crossed that line in terms of materially prejudicing an adjudicative proceeding due to its creation of an imminent and substantial detrimental effect on that proceeding? So the response there is, we have to deal with potential jurors who have incomplete information. We need to at least sensitize them to how incomplete their information was. So I'm not really talking to the public. I am talking to you, juror number 1. You, juror number 2. I want to tell you what's really the truth, at least my version of the truth. Then later on that same page is Mr. O'Mara making comments about what the defendant is or is not in terms of his family members. Is that proper? The next article I have is the May 2nd, 2012 Miami Herald, I apologize. He's talking about, in terms of comments about his client's MySpace account, in which the defendant talked about negative commentary about Mexicans. And so again, he's saying, well, yeah, that's been hacked enough, but those posts, the Miami Herald story is accurate in that the defendant did make derogatory comments about Mexicans. They were written by his client. And on page 3 of that, he said he began his foray into social media in part to response to the avalanche of emails and phone calls that were overwhelming his office. It'd be irresponsible to ignore the robust debate taking place online about his client. Is that what we're supposed to be doing? June 4th, 2012 article, and I apologize, Miami Herald also. And Mr. O'Mara, again, commenting about his client. Third quote there, Mr. Zimmerman understands that his mistake has undermined his credibility, which we will have to work to repair. He's trying to explain in terms of the money why there was lies or misstatements or mistakes, whatever we want to call the hiding of the money. On Miami Herald, July 17, 2012, the witness number 9 accused Mr. Zimmerman of something. Mr. O'Mara, on page 2 of that article, this refers to as the accusation as a side tornado that comes with a hurricane. And then he says it's completely irrelevant and now we have to waste 50 hours on something we'll never make in the courtroom. He, the defendant, meaning the defendant denies it. He is saying that it never happened. Now, that's the defendant commenting, defense attorney commenting about what the defendant is saying or not saying. That hasn't been reported anywhere, but that's what he, believes the defendant is saying or not saying. Again, is that proper? And then the Miami Herald, September 20th, 2012, talking about the story about, I believe it was the Ostermans who ended up writing a book in this case and also appeared on Dr. Phil's. And that is dated September 20th, 2012. Mr. O'Mara's on page 3 of that article. Mr. O'Mara is commenting about, now he's saying, he never had heard about a struggle for the gun. He did read a draft of the book before it was published, but felt asking Osterman to change details would amount to witness tampering. Quote, he's a friend of George's trying to explain George to be a different than the way he was perceived to be. Great. That's a story that's not been told. O'Mara said, I don't like him talking about things George spoke to him about in confidence. I didn't like yet another statement of George out there for review. It's more of a headache. Mr. O'Mara, although he questioned whether Osterman's memory is accurate, Mr. O'Mara admitted that between Zimmerman's various interviews to police, his father and brother's accounts to the press, and now Osterman's, there are several variations of what happened that night. But he characterized the discrepancies as surmountable obstacle. If everybody's story was exactly the same, then it would smack of a lie. And towards the bottom of that page, we will be able to respond to the 6, 7, 8 different renditions of the story and how and why there are different statements. The jury's going to believe what the jury's going to believe. My point in highlighting that part is, earlier, some part of my argument to the court, there was reference about that all his statements were consistent. Now he's saying they're inconsistent. But that is what jurors are being told in terms of the defendant's statements. Now that I think the last thing is he's made 6, 7, 8 different statements, and we'll just have to deal with it. Is the defense counsel allowed to talk about that? About the facts of the case? Your Honor, in conclusion, case is set for trial June 10, 2013. This case has had an extensive amount of publicity, not just by the print or the television media, but the internet, social media, etc. Where do we stop? Where do we have the ability for both sides to get a fair trial without commentary by counsel? And so I would submit that and ask this honorable court to enter an order prohibiting any attorney involved with the prosecution or defense of this case, or any personnel employed or affiliated with said attorneys and law enforcement personnel from making or releasing any extrajudicial statements to the media about the following: facts of the case, any evidence or the lack thereof in this case, the strength or weaknesses in the case, the credibility or the lack of credibility of any potential witnesses, and opinions about guilt or innocence, and any appropriate or anticipated penalty. And I guess I'll just wait to, if I could, just respond to whatever arguments very briefly that are made by defense counsel, because I just don't have, obviously, defense counsel, Mr. O'Mara, but also the media attorneys.
Thank you.
Thank you.
Mr. Miller or Mr. West, who's making the argument?
I'm going to, it might make sense to have Mr. Ponce make his argument on behalf of the media so that they have that of record. I'm sorry. Or, I'm sorry, whoever's going to.
I think he should go.
Okay.
And I have read your response in your memo.
Okay. Macintosh, of course, was in 1977, before we had an internet and before we had cable TV, I think. We had some cable TV, but it certainly wasn't what it was today. And it was also 14 years before the case that I think really rules our decision-making process here today, and that's Gentile. And I know that you've read that, and I've cited a number of different ways in my, my response, but I just can't get away from the idea of having to highlight a little bit about what Gentile tells us. But I'm going to do it in the context of what we've been responding to. Racist murderer, shot a young unarmed kid through the heart, tracked him down, went after him, profiled him, confronted him, attacked him, for racist reasons, and because, according to the state, actually, because of ill will and hatred. And that comes from the state's surrogate. That comes from Benjamin Crump and Natalie Jackson. Because, and I have it for your review, though there's hours and hours of videotape, should you want to take the opportunity to review them, it really starts way back in the beginning. And I'm going to just reference to you how it sort of started so that you get a context for where we are today. Now, Crump and Jackson needed a media strategy. On March 5th, this is 10 days after the event, Jackson brought in Ryan Jewelson, a publicist who had worked with her in a number of high-profile cases. After speaking with Tracy Martin, Jewelson said he would take the job for free and then went to work pitching the story to national media. Crump knew from his experience on the boot camp case that publicity could force officials to act, but it would require persuading two people who had never stood before a television camera to withstand the spotlight. I got on the phone with Tracy Martin and told him, "It's not going to be any fun, but this is the only way to find justice," Jewelson said. "You're going to have to bare your soul and express your emotions and inner grief." Martin and Fulton agreed. There's only one problem. At first, the media wasn't interested. Jewelson pitched the story to a long list of media contacts. Eventually, on March 7th, Reuters published the story. So, here's what we are starting this with. Now, unfortunately, we start with the unfortunate death of a 17-year-old boy. And we all know that it was unfortunate. The facts will speak for themselves, but they seem to be out there in a number of different ways. I say that because it really is the context under which we have to look at how we are to be acting in this case. Crump and Natalie Jackson decided they were going to make this a national media case, as they did other cases, because sometimes there are pots of gold at the end of this case that don't just include criminal justice. They include a lot more than that. So they bring on a publicist to bring out the case. Now, did they bring out the facts of the case? One would truly have hoped, because that would make a lot of sense. But what they decided to do instead was to simply just come up with a selling point. And what was their selling point? Benjamin Crump on Piers Morgan got out of his car in the rain, profiled, pursued, confront Trayvon Martin, and then kill him in cold blood, even though he was unarmed. This is, in fact, the words of a surrogate for the state. Not saying that they were in a conspiracy, but the reality is what they are doing is presenting the state's case. Crump, of course, argues time and time again, but I'll show you a couple, that the entire Sanford Police Department is racist. Matter of fact, he goes on to state, in effect, that the state attorney's office is racist because they wouldn't prosecute. So what he does say, again, to Piers Morgan, we don't know why the powers that be at Sanford Police Department and the state attorney's office have conspired to sweep the murder of Trayvon Martin under the rug. Now, Mr. Crump carries an Esquire after his name as well, and is just as bound as I am by 4-3.6. And then further on, and again, we have the video, so I'm not going to bore you with all of it, but I will present it to you if you want. Mr. Crump disputes the evidence, doesn't exist, and agrees that there's an attempt to cover up the SPD investigation. And what does he say? Tampa Bay Times article. In court you have the jury, Crump says, our job is to get the case to a jury. We need to fight first in the court of public opinion. The jury is the American people. His plan, and I guess he's entitled to it, is to completely sway national public opinion on this case in favor of his client, the Martin family, to allege their story that my client committed a heinous act of murder. Now, though I guess he has First Amendment rights as well, and though I believe he's as well bound by our rules, he has decided to take a story, and I would argue to you, spin it. Because he says, for example, and I'll, again, the video clip is available, but basically what he says is when a video was leaked by the same media company that Mr. Crump was with during an interview of a heretofore unknown witness. But anyway, a police video was leaked by the media showing Mrs. Zimmerman walk past a camera. And he uses that to say, the cops are conspiring against my client. It is obvious there are no injuries on Mr. Zimmerman, and therefore they're racist and this is a conspiracy. Words like that, and look at the video, decide for yourself. What's interesting, however, is that when we fast forward to the state's press conference, and they tell us in the press conference that Mr. Crump and Mr. Parks were in daily contact with them since their involvement in the case, that means that they were involved with them when Mr. Zimmerman's records, medical records, were disclosed to Sanford PD because they had them by March 2nd. So it would seem, since they had daily contact with the investigation, that Mr. Crump would then be aware of the records that suggested the injury to the face and the back. They were similarly aware then, because SPD have it, of the picture that took us, of the picture of Mr. Zimmerman in the police car with the blood on his nose and on his face, and also the pictures taken at Sanford PD with the blood on the back. I mention that not to talk to you about a whole bunch of blood, but when we are looking at what Mr. Crump and his camp have done to this case, it is particularly relevant for us to look at the environment into which Mr. Zimmerman was thrown. Since his involvement in March, they have traveled the countryside, traveled the nation, the Martin family, and Mr. Crump and Miss Jackson, and again, sort of their entourage, And they have pitched this very same story across America, that Mr. Zimmerman is a racist murderer. Those are his words, not mine. To argue that that there should be some justice. Well, I'm very, very aware of this case, the facts of the case, and how justice is going to be had in this case. But here's the problem. Today's Sentinel, tell how long I've lived here, it used to be the Sentinel Star. Today's Sentinel, today, after everything that the state seems to think that I've accomplished, and we'll talk about the efficacy of what I've done as far as the people who's actually seen the website, but today, 72% of the people believe George Zimmerman cannot get a fair trial. What should that percentage be? 50-50? No. We all know what it really should be when we think about it. That should be 0. That should be 0. I should not have to talk to a jury, potential jury, 6, 8, 10, 12 months from now and say, just curious, are you one of the 72% that thinks he's not going to get a fair trial, and maybe will that help me or will that hurt me, and why do you think that? What infected you to the point that you think my client can't get a fair trial in this case? Well, what's infected him, that juror, that potential juror, is what's been going on in this case. And it's been run, unfortunately, by a publicity team that is getting a great deal of yardage out of keeping a story alive. Now, I could easily go into how the story is untrue, but that's evidence, and we don't need to. That's not the point here today, is whether or not the story is true, or why the story is not true. I think it's significant that it's untrue for this reason. We go back now to Gentile, and what constraints exist with lawyers. Now, I don't know what constraints, I did not know what constraints existed in '77 because I wasn't a practicing lawyer. I do know what Gentile told us in 1991, and Gentile was decided upon when I think the internet may have been identified, but it wasn't active. And certainly we don't have what we have in 2012. Now, I half joked as a remedy to this in my response to you when I said, just turn off the media and just turn off the internet, and then we'll be okay. Then things will settle down, things will calm down, and we won't have to worry about it. But Gentile, though they didn't know it was coming, really set forth the parameters under which we have to act as lawyers. Remembering, again, as I know you do, I'm sorry, Your Honor, 1 second, that in Gentile, the Nevada State Bar, their restrictions on lawyers commenting were greater than ours. Because under ours, you get that second level where it has to be an imminent and immediate threat to the proper presentation of justice. That add-on in Florida is a stricter, you would have to show, for example, I know you know the argument, that I was acting in such a way that my comment was imminently going to threaten the administration of justice. But let's just stick with Gentile for a moment and its standards and what it says in Gentile, which I think, I'm surprised that it wasn't even referenced by the state, because it is in fact the standard that you must decide this case on, this suggestion. So looking at Gentile, and again, I'm going to belabor it just a slight bit, knowing that you've already read it. One level that I contend exists in this case, and that's why I just went through everything that we are fighting against, is I contend to you that the case against Mr. Zimmerman was created for reasons far outside the facts of what happened that night. And I get that because we've now done some discovery. I get that because of the motion that's still pending, which is when I sit down with a Sanford police officer and he tells me that everybody in Sanford Police Department, from the chief to the investigator and the other 11 or 10 in between, made the decision that there is not sufficient evidence to try this case, to charge this case. And he also tells me that the state attorney's office was involved in that situation for the last week of that decision-making process, and they too agreed that there was not enough evidence to even charge this case because they read 776 and looked at what has to be shown and what has to be defeated in order to charge somebody with a crime. When they tell me that in a deposition, and then when I see that what was planned in that same, and now that we're finding out this discovery, what was planned was a presentation to the grand jury, which you would think would be an appropriate way to handle a case of this magnitude and maybe this concern. When that decision is then taken away from the local state attorney by the governor and given to an out-of-area prosecutor who then doesn't avail themselves of the grand jury process, and I've made this in a motion before, and he reminded me in his response that they don't have to, and I get that. They could charge it with whatever they want. But when that decision is made not to even take it to a grand jury, and I sit back and I say to my client, there's something afoot here. There's something afoot well beyond what he did that night. And what that is political influence. And I don't say that just because Gentile says that if it's political speech, it's further protected. Tell me where the facts don't support that everyone who looks at this case initially doesn't think it should be charged, and yet, lo and behold, the governor involves himself in the process, and we have a second-degree murder charge under these facts. I contend to you, just as Gentile contended to his public, that he has an absolute right, not right, the obligation to balance what has been done to Mr. Zimmerman. And I know that you've read through the Gentile, and I highlight some of the comments that say, the Supreme Court noted that Gentile's speech, and let's not forget, Gentile's speech was, this is a cover-up. The cops actually did it, and they're making my guy the scapegoat. Now, I'm not saying cops did that tonight, but did that night. But the reality is there is at least questions now from the deposition of one witness as to what the true motivation was. And when we look at Gentile, it tells us very specifically that we have the absolute right to comment on that. Supreme Court stated, there is no question that speech critical of the state's power lies at the very center of the First Amendment. Nevada, in that case, seeks to punish the dissemination of information relating to alleged government misconduct, which only last term we described as speech, which has traditionally been recognized as lying at the core of the First Amendment. It would be difficult, they go on to state, to single out any aspect of government of higher concern and importance to the people than the manner in which criminal trials are conducted. And they say that it is, in fact, the press in Shepard versus Maxwell, an excellent case for looking at the need for the press involvement. The press guards against the miscarriage of justice by subjecting police, prosecutors, and the judicial processes to extensive public scrutiny and criticism. Public awareness and criticism have even greater importance where, as here, they concern allegations of police corruption. And as I say in the top of page 3 of my memo, I do not want it to be uncertain that over the last several weeks it has become apparent to Mr. Zimmerman that there is something afoot here. And we should not be stopped from doing at the very heart of the First Amendment, which is to bring that to light. And we know that because 72% of the people seem to have bought the story hook, line, and sinker already. And that's what we're trying to fight against. So further, when we look at what Gentile did, and what he said. The court summarized his desires, Gentile's desires, by stating, rather than it being an admission that he sought to materially prejudice an adjudicated proceeding, petitioner sought only to stop a wave of publicity that he perceived as prejudicing potential jurors against his client and injuring his client's reputation in the community. Let's, just for a moment, let's think about Mr. Zimmerman's reputation in his community today. He's been in hiding. Well, let's back up just a little bit. He was in hiding, then he involved himself every time the police wanted him to come in. He gave in, went back into the state when they wanted him to. He gave several statements. There'll be arguments over whether or not there are inconsistencies, but he voluntarily gave several statements, took a voice stress analysis, did a recreation of the scene, did a voice where he would act out when he screamed for help that night. He was acting it out again so they can try and compare it. He did everything they wanted him to do. And what's his reputation in the community today? Well, we'll get to that in just a moment. As to what people think of Mr. Zimmerman, why 72% of the people think he won't get a fair trial, and why today he's wearing a bulletproof vest and living in hiding. So, if Gentile is to be given life in this courtroom, then let's give life to the very words of the Supreme Court when they tell us that responding to that tidal wave of information against Mr. Zimmerman is not only appropriate, but the Supreme Court says that's exactly what we're supposed to do. An attorney's duties, they tell us, do not begin at the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for the client, just as an attorney may recommend a plea bargain or a civil settlement to avoid adverse consequences and possible loss after trial. So an attorney may take reasonable steps to defend their client's reputation and to reduce the adverse consequence of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives. A defense attorney may pursue lawful strategies to obtain dismissal of the indictment or reduction of charges, including an attempt to demonstrate in the court of public opinion that the client does not deserve to be tried. Gentile, 1043. Now, what have I done? We had a website. We have a website. Very unique. I've never done one before. I've never heard of one done before. And as I stated in here, I did it because the day that I got involved in the case, 75 reporters showed up outside my door. It was this amazing little crescent around my front door. 2,000 emails. Closed down both of my email accounts, and it closed down my phone system. And we needed something to do. So having never really, I've dealt with high-profile cases before, but obviously nothing like this. So we got extra lines, we got extra emails, and then we decided we will do a website. We will not advertise on that website. We will talk to the Florida Bar about it before. They haven't made a final decision, but we pass it all by them, and they said it's not advertising, just be careful. And we created a website with principles to try and figure out how we could accomplish some of what we needed to accomplish, which is dealing with the enormity of information flow in this case, and doing it in a way where, in effect, we can sort of stick our fingers into the enormous, not even current, torrent of information that's flowing past us in this case to see what's there. So we come up with a website. And we come up with a website, and we made these up. I mean, we didn't get this from a textbook. We sat down and tried to figure out how we're going to do this in a way that is ethically proper, responsible, in a case where we do, of course, have a 17-year-old victim who's passed away, and do it in a way that makes some sense, but zealously represents Mr. Zimmerman. Now, I will tell you that the internet has provided an enormous, enormous amount of information. It has Some of it is horrid. Some of it is racist. Some of it is full of hate. And some of it is really good information. There are people out there who spend 100 hours looking at some of this evidence and digesting it. I'm sure that the state has benefited from them emailing him, and I'm benefiting from the people that they're emailing me. Well, you know, this is 2012, and I'm sorry, but I used to have the books on the shelf. Those days are long gone. We now have an active vehicle of information that I will tell you, not today, but 10 years from now, if a defense attorney is not searching the internet for information like this, then they're committing malpractice. So we decide we're going to open up a website, and you have it in front of you, so I won't bore you with many more of the details, except to say that we tried to come up with a plan to present our internet presence in a way that makes sense, but protects the process as best we can. So if I might just have a moment, I do want to go over those with you very quickly. You have it in front of you, I think, the 7 rules. And within that, what we have tried to do, realizing that we were going to have an internet presence, of course, that was the first decision that was made, we decided to fill out those principles. And within those principles, we say exactly what's there. You've read it or can read it. And the purpose of which, the entirety, the global purpose of which was that we would respect the process, we would respect the individuals, and that we would use it appropriately to gather information, to act as a source for information for the media, who of course was still completely inundating all of my staff with requests. And we did it in a way that we thought would be at least principally appropriate. So if you have that, then, and I would suggest to you that that is a way to properly do this. We have modified it along the way. You'll see that in the various, I do want to make sure that you have all of the information that I intended to forward to you, so just give me 1 second. We've done it in a way that tried to be reactive to changes. For example, the state mentioned Facebook. Facebook was an opportunity that we came up with, again, to try and allow some discourse, but if you look at the discourse we allowed, we did not involve ourselves in it. When it finally sort of ran its course and it devolved into something that was just a lot of people bickering back and forth, we decided that that wasn't purposeful anymore, and we took down Facebook. It's there. If you want to look and see what's on it, if you have an internet, we'll go right through it right now. You can see what's on it, but I will tell you that the information flow that's on there, and I'll present it to you in a second, was as clean as we could make it in this new day and age of an internet presence. And then we have Twitter. And if you look at our Twitters, I'm sorry, I used to get that right, look at our tweets, you will find that we are intentionally vanilla with what we say. The majority of our tweets are very simply that. They are, here is information that was filed. I would challenge the state to suggest to me that there is anything on that presence that is advocacy. Now, let me back up. I think I can advocate. The suggestion that the state is saying that we not comment on the evidence, I may have caused that problem because I told Mr. Delrianda early on that I don't think that it's good to comment on evidence. There is no prohibition to that. The 4-3.6 doesn't say you're not allowed to comment on the evidence. There's truly no prohibition on commenting on a particular piece of evidence, particularly if they're in controversy. But I've been very hesitant to do it, but I just want to be clear that it's my position that there is not an affirmative obligation the Supreme Court case out of 1977 suggested, but that is not what is followed up with in the Gentile case, nor is it followed up by with any of the more recent Florida cases that deal with it. But now let's talk for a moment about, after we realize the context, the universe that we are now forced to live in 2012, let's now talk about for a moment what effect we really have. I actually have somebody who can testify to it, but I'm going to try and move it along by just giving you the hearsay version myself, and if it needs clarification, we can certainly do that. But the nice thing about living in the world of Google is they keep records of everything. They actually have every search they've ever done, which is in the over trillions or whatever the next quadrillions is. But one thing they do is they keep track of all internet traffic on our websites and all searches. So I will tell you, and present it more formally if you need it, that when the Trayvon Martin passing occurred, when the event that night occurred, over the next week or so, and in direct relation to the March 5th presentation by the Crump group, there was approximately 50,000 hits or volumes for the word Trayvon Martin, 20, I said thousands, I meant millions, for George Zimmerman, as of when that happened. That is now down to date to well less than 2% of that for each one. In our site, the site that's being complained of by the state, we have had a total of 263 visits. Unique visitors, meaning a couple of people come back more than once, 157. So 157,000 different people looked at something on our site over the 6 months it's been around. And maybe we'll look about one page or two, there's like several on it, but they look at it. What's interesting is when we start drilling down into that and what that means, because that's, of course, nationwide. If, in fact, we look at those visits in the Central Florida area, that area from which we would potentially pick a jury, and we've done the numbers, actually, Google has done all of the numbers, of the potential jury venire that we would pick from, less than 0.5% people have looked at that website. Now, I really wish I could say that 60% of the population looked at it, but less than 0.5% of the people. And part of the reason for that is simple. This is not broadcast media. Websites are, I don't have the right term, got to go to it media. You have to want to go to it. Websites don't broadcast out to anything, like some of these, what they call pop-ups, where you're just sitting there and it says, buy this. If you want to visit that website, GZ legal case, you have to decide to go to it, which I would suggest, similar, it's funny because Mr. DeLeonda suggested some recent rulings by the Supreme Court on tweeting. We don't want jurors to tweet because we don't want them to get any information except from beginning to opening the case. But we also have to look at, what's out there, what the traffic is and what it might support and what people do. In the same sense, the Supreme Court has said that they're considering changing the way we look at website because it's not on demand. It's on demand. It's not broadcast. You have to go look for it. And they have sort of determined now they're going to look at even the advertising rules differently because if someone wants to go to your website. Similarly in this case. So, starting to be a long-winded way to say what we have done was deal with a case that when it got to my doorstep was already in the throes of an enormous overriding tidal wave of misinformation, I would contend, but supported seemingly by some of these anecdotal statements I've said, like 72% of the people don't believe they'll get a fair trial. So when we then take that back one last time to Gentile, and it tells us that what we are supposed to do is to attend to affect that negative information that exists because of outside sources. It's usually the prosecution and the police. We all know about the perp walk. You know, cameras are there, guys head down, walking around. Well, you know, now what we have is the internet. So it's all over the place. And I don't blame them, because were they here today, they would say to you, we have an absolute First Amendment right to present our client's case in as zealous a manner as we can. And if we're looking to get money from a homeowners association or something like that, and we can suggest that your client's guilty or your homeowners association is guilty, they can do all that. I am troubled that that avalanche of information or misinformation now falls and buries my client. I just don't think we can do anything about it. What we shouldn't do about it, however, is to say that the state surrogate, or at least someone acting in a consistent fashion with the state's position, can have unfettered access, as they've well shown, to the media, to social media, and that the one person who represents Mr. Zimmerman and who does his presentation under certain rules and regulations, and in a way that seemingly, and I argue to you, is nowhere near close to the balance of 4-3.6 when we look at it in 2012, that you not deny my client's First Amendment rights, first of all, but more importantly, his Sixth Amendment rights. Because after all, when we look at what the Sixth Amendment really does tell us, and it's somewhat instructive, we tend to not think about it sometimes, and we tend to just go on by and say, don't worry, he'll get a fair trial. But what the Sixth Amendment says to us is that he is to be protected because in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state. Now, the state is saying that I'm making the jury impartial. But because I go in there and say, yeah, George's credibility was affected because he didn't tell the absolute this or the money question. Yeah, okay. And that somehow is going to violate 4-3.6, saying that there is an imminent threat to the proper administration of justice. If I go on Piers Morgan and say, wait until you hear all the evidence. Since we're talking about hearsay, if I present to you Professor Gillers out of New York University, who came out and said, this is the most ethically appropriate way to handle social media. He's the ethics professor at New York University School of Law, that he's handled. If I was to bring a sitting state attorney, not an assistant state attorney, but the state attorney, who called me up unasked and left a note that said he and his entire office believe that the way that you're handling this case have quelled the fires that were brewing in Seminole County, have brought a sense of peace to this case, and have done it in a way that they're proud to call me a brother lawyer, then that's actually the way this is supposed to be handled in 2012. Because what we can't do is ignore the reality that the Sixth Amendment tells us that we have to make sure, although the state gets their right to a fair trial, we know who the Sixth Amendment talks about. And we know that right now, if we pick a jury tomorrow, we ought to go through 7 of 10 of those potential jurors and go, why don't you think he'll get a fair trial? And we really know why. Because they think he's guilty. They've listened to it all. They've listened to every word of it. They've heard Mr. Crump time and time again just say that he's killed a child. They've looked at the picture of the 12-year-old, and they said, how could you do that? Right? We know that that's what's happening. Now, if I was on the top of a mountain screeching it out, okay. If I violate 4-3.6, someone should tell me. What shouldn't happen is you shouldn't sit here and say, everyone else can talk, we can do all that, but Mr. Zimmerman, it's not happening. I'm going to shut your lawyer down because the 1977 case says I can. I'm going to ignore everything that the United States Supreme Court in Gentile tells me a good criminal defense attorney is supposed to do. And I'm just asking you, let me do it as long as I do it the way I'm supposed to, which is ethically and within the bounds of advocacy, and more importantly, the bounds of our rules.
Thank you very much. Mr. Pons?
Your Honor, if I'm counting right, we've had about an hour and a half's worth of argument on this motion, and I know these are sometimes famous attorney last words, but I'm not going to be very long. I want to bring this back to the standard Your Honor has to apply. The standard that was, I've been working with this case for a long time, and I'm never sure whether it's Gentile or Gentili, but that case, it sets out the standard as it's been followed by Florida in the Rodriguez and Aquamar decisions that we cited in our papers. And the standard Your Honor has to apply is, are statements substantially likely to materially prejudice this trial? Prejudice does not mean that jurors have heard about it. The goal of this process is to put people in that box and not be concerned whether they've heard Mr. Romero speak before, or if they see him and say, you know what, I remember seeing him on TV, I remember reading about him. That's not the goal. Prejudice, as it's used in this test about substantially likely to materially prejudice proceeding, prejudice means that the people sitting in that box cannot be impartial, that they will not decide the case on the evidence despite your admonishments to them that they will. Mr. De La Rionda said, there's been so much publicity out there and so much talk, and this case has had so much publicity that it might take us weeks and weeks to do voir dire. I say that's exactly right. Our Constitution, and the cases interpreting our Constitution, say that a gag order is the last alternative. That if it takes weeks to do voir dire to make sure we impanel impartial jury, that's what we have to do. It's a combination of voir dire, admonishments to the jury, but if that's what's necessary, that's what has to be done. I want to read, and we cited the Murphy decision in our paper from the U.S. Supreme Court, and this is cited at 421 U.S. 794, and it's a 1961 decision. The U.S. Supreme Court said, to hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused, without more, is sufficient to rebut the presumption of a prospective juror's impartiality would be to establish an impossible standard. It is sufficient if the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in the court. So what this comes down to, Your Honor, is have you been presented evidence? Has evidence been given to you that the only way to make sure we have an impartial jury, not an ignorant jury, the only way to make sure we have an impartial jury is to issue a gag order saying no one involved with the case can speak? And restate it a little bit, if Your Honor was going to sit down and write an order, and the cases are clear that if you're going to issue a gag order, you have to make specific findings of fact showing how the evidence establishes a standard. If Your Honor was going to write that order, what evidence could you possibly point to that it's going to be impossible to seat an impartial jury unless you gag the attorneys? I don't think there's evidence been presented to that. And Mr. Romero read extensively from Gentile, and I'm not going to go through that again, but I think that decision makes clear that it is very hard to issue a gag order. The state has not cited any decisions in its paper where any time recently a court has entered a gag order, and it's just because it just doesn't happen anymore. The modern trend is to do exactly like Judge Lester did at the beginning of this case, is to remind the parties, the counsel for the parties, that they're governed by Florida Rule of Professional Conduct 4-3.6. And earlier at the beginning of the hearing when we were dealing with a different topic, Your Honor said, the attorneys are officers of the court and you expect them to abide by the rules that come with being an officer of a court. And that's exactly what you should do here. Let 4-3.6 and these attorneys and everyone's attorney be guided by those rules. It's dangerous when a court starts wading into what is permissible discourse about a subject. We shouldn't have courts telling people what they can talk about, what they should talk about, or I'm concerned if you say X, people in the blogosphere are going to say Y. It's dangerous when we start getting into a situation where we're having the state of Florida ask a circuit court judge to start wading into what people should or shouldn't say. When we start going there, that's a dangerous place. And Your Honor, unless you have any questions about things in our paper, that's my presentation.
Well, thank you very much. No, I don't. Mr. Thomas?
Thank you, Your Honor. Your Honor, just to reiterate very briefly what Mr. Pond said, the standard here is very high. You're dealing with not only the First Amendment, the Sixth Amendment, but a history of dialogue in cases. I was lead counsel in the Danny Rawling case, where Judge Morris told both the lawyers what the requirements were, and there was no gag order entered in that case when there were 5 murders and probably the most intense publicity. There was no gag order in the Casey Anthony case, Your Honor. I think that if you adopt what Mr. Delaronda says, when television was invented in 1947, he could have said, well, this is a medium that can affect everything differently than the radio. I think we have to live with the medium we're given. And unless Your Honor can look at one of those statements from an evidentiary perspective that Mr. O'Mara said and say, that's the statement. That's the statement that's going to adversely affect. And if we look at the history of cases where there was outrageous behavior that affected trials, I don't think any of the statements come close to the sort of prejudicial statement that, in fact, today, if you look at what Mr. O'Mara said in this courtroom about the conduct of the state, I think those are far more prejudicial in an open courtroom than any of the things he said on the internet. Your Honor has at your disposal an enormous arsenal of tools to protect the process. You can have more jurors come in. You can do individualized voir dire. You can sequester the jury. There are hundreds of high publicity cases when that happened. I mean, the verdict in the Casey Anthony case, the verdict in the Danny Rawling case, where the Florida Supreme Court looked at that and said, Mr. Rawling, even with the intense publicity there, received a fair trial. Your Honor can accomplish that. It may be more difficult, but I think our system deserves that sort of scrutiny. And to think of going to limit anyone's speech in a circumstance like this, where there's a national debate on the stand your ground. It's not just this case. There's a national debate, and we live in a place where the marketplace of ideas and the importance of the First Amendment is essential. Thank you, Your Honor.
Thank you very much. Do you have a response?
Very briefly, Your Honor. I know the court's...
Now, Mr. Ponce and Mr. Thomas promised me that theirs would be brief, and they were.
Mine will be very brief. In response to defense or counsel for the media talking about the Casey Anthony, I believe Judge Perry did hold Mr. Baez in contempt. I don't know if it was an outright gag order, but I believe he was held in contempt. But I think the record would speak for itself. The bottom line, Your Honor, is there's been mention of 72% poll. I'm not aware of that poll. Maybe it exists, but I haven't seen it in terms of feeling the defendant is guilty. And Mr. O'Mara said that Mr. Crump works for the state. He's not working for us. He's working for the big...
I didn't get that that's what he said.
I think he said he was a surrogate of the state, and he's not. He's not. It's just like they distanced themselves from the defendant's brother, who they said, we don't have anything to do with him. He's doing whatever he wants on his own. Mr. O'Mara is the same. Mr. Crump is the same term. Now, finally, regarding political influence, the record would speak for itself in terms of when we got this case and what we did or we didn't do. But Mr. O'Mara keeps throwing out, Sanford Police felt this or Sanford Police felt that. Sanford Police submitted the case to the State Attorney's Office. The State Attorney's Office was still investigating the case. When we got involved in the case, we still completely investigated into stuff that came after all that. Thank you.
Thank you all very much. I'm going to reserve my ruling on this, and I hope to have a decision made and an order rendered on Monday. So we'll have to consider. Let me see if I can get Mr. flood back on the phone, well, on the phone. Oh, okay. I won't talk to him until you finish changing your paper. I'll remember to say.
Still bad to the bone iPhone. Leave a message.
Okay, I've tried twice. Let's go ahead and go forward with
If I might, before we leave that, I'm certainly not going to argue anymore, but what I do have, as I mentioned to you earlier, and I want to present to the state, this is just a summary of what I've argued and the points that I've made, but what I've done, this, which might make your life a lot easier, has everything that's on it here, but you can use this with an internet-connected computer and you can get right to the links. So I will present to you the summary, which I just printed to the state, and the exact copy of it is on a thumb drive so that you can look at the links should you decide to over the weekend.
Any objections from the
No,
state?
Your Honor.
Okay, I will go ahead and take that.
I'm sorry. Thank you.
You're lucky I know how to use a thumb drive.
Yes.